right, so on the line holding our first caller this evening is Sarah, and Sarah is from Jackson. Welcome to Law Call. And what is your question this evening, Sarah?
I was walking in a big store and I slipped and fell and I broke my leg. There was no warning signs anywhere in the store. So what should I do next?
Thank you for your
Great question, Sarah. This comes up quite a bit. Here's what it's probably going to come down to. You can prove liability or negligence. You hear that word a lot. Really, that just means fault against the big store. One of two ways. Number one, did they have some sort of condition like water or oil or some substance that's slippery on that floor for a period of time long enough to give the store notice? We don't hold stores to be perfect. You know, did they have 5 minutes to clean it up, 10 minutes to clean it up, 20 minutes? When you get past about 5, 10, 15 minutes, then you start to, the law shifts that burden back to the store to say, well, you had time, a reasonable amount of time to fix that. Okay, but if the substance only been there a couple seconds, it really wouldn't be fair to hold the store or anybody liable for that, unless, and that leads me to the second way you prove liability or fault against a big store, is did they put the substance there themselves? And the most classic example of that is when the floor mops, when the store mops the floor and then doesn't warn about it. They mop the floor, but they don't put up one of those yellow or red or orange wet floor cones or signs, and we've seen them all everywhere. And so those are the two ways that you can recover. And Sarah, I'm sorry that you broke your leg. It sounds like you have a serious injury. What's going to be really important in her case, Tamika, is the surveillance video from that store, and that's why she needs to hire a lawyer, or at least talk to a lawyer immediately so they can send a notice or preservation of evidence letter right now, because if you don't, they'll get rid of that tape.
Okay, and speaking of evidence, in her situation, right then, what if a person does fall, what would you suggest they do at that moment at the store?
I think it's so crucial to get, once you're situated and sitting down, get a photograph of what you fell on, because the clients that come in the office and I say, well, what did you slip and fall on? They say, I don't know. Those are very tough cases to prove, because then you're going to have to go and rely on other witnesses or the video or the store's own employees. And guess what, Tamika? They don't want to help you. Okay, they're not going to remember what that substance was. They're not going to remember a substance at all. So you never want to have to rely on the store to prove your case.
Okay, since we're talking about like wet surfaces, what about areas that we know they're going to be wet, such as water parks and pool areas, and you're hurt in areas like that? Do they get off the hook of injuries? Because obviously, you know, there's lots of water around.
Yeah, what it can come down to then is what's called comparative fault. And that just means that a jury gets to decide whether or not the plaintiff knew, the person that filed the lawsuit knew that there was something dangerous, in addition to the store knowing, or the facility knowing there was something dangerous. And the jury can assign, say, 50% to the pool or the park and 50% to the person that was hurt. So the law accounts for things that might be open and obvious, but you can still be found liable for that. So the law accounts for that situation.
All right. Well, thank you so much for those questions. And